Hello everyone, today I'd like to discuss you about the concept of active and passive euthanasia, the jurisprudential journey and important case laws in relation to passive euthanasia in India, and the important judgment of the Honorable Supreme Court Harish Rana versus Union of India, which reshaped the legal and ethical landscape in relation to end-of-life care. First, I like to discuss you about euthanasia. In common perspective, we often call it as mercy killing. Euthanasia, we can say that's an intentional acceleration of a death of a terminally ill patient by active or passive means, which relieve the patient from endless pain and suffering. It may have two forms, the active euthanasia and passive euthanasia. In active euthanasia, it's like intentional and deliberative act to end the life of a patient by providing lethal injection. And in case of passive euthanasia, in contrast, it's like omission of these acts. Like if a patient who is in permanent vegetative support, we will remove the life support, which will cause death of a patient. So this is passive euthanasia. If we talk about the legal position, then active euthanasia is not recognized in India, but passive euthanasia is recognized in India. Now I like to discuss you about the important judgments of the Honorable Supreme Court which shaped the journey of passive euthanasia in India. The first case that stands for long is Gyankor versus Union of India, which states that right to life does not include right to die. This was the position put on stage for long. But after this, the recommendations of the Law Commission in 196 report, in 241 report, they talk about the implementation of passive euthanasia. So the Honorable Supreme Court reshaped the concept of passive euthanasia in Aruna Sonberg case. In Aruna Sonberg case, the Honorable Supreme Court held that the person who is completely in permanent vegetative support, passive euthanasia is allowed subject to strict judicial intervention. So this was the position. Then later, the same philosophy was recognized in common cause case in 2018, where the Honorable Supreme Court held that the right to life includes right to die with dignity. So right to die with dignity is an important concept of right to life under Article 21 of the Constitution of India. Now, the recent Harish Rana versus Union of India, the Honorable Supreme Court allowed passive euthanasia and allowed life support to of a patient who is in permanent vegetative state since last 13 years, because there is no scope of improvement, just extending the life of a patient by artificial means, and there is no therapeutic improvement. So the Honorable Supreme Court also directed that it must be approved by a two-tier system, primary medical board and secondary medical board, and also directed that the patient be transferred in a palliative care so that it will relieve the patient from continuous pain and suffering while undergoing this process. In the end, while concluding, the Honorable Supreme Court also requested the Union of India to frame a comprehensive policy in relation to such cases, and I think it will definitely usher a new era in medical jurisprudence. Thank you.